But there are a few really key things that I do want to talk about. And I want to start by talking about public charge. Probably folks have heard about this. Public charge is an issue for when you're applying for admission to the United States. And that really means applying for a green card or applying for a non-immigrant visa. And public charge doesn't apply to everyone. You're mostly going to be talking about folks who are applying for a green card based on a family-based petition. And public charge has been around forever in our, basically as long as we've had immigration laws, there's been public charge involved in it. And it has kind of changed over the years. Since the end of the Clinton administration, public charge has been defined as someone who's primarily dependent on the government for subsistence. And so you're talking about public cash assistance that can be temporary assistance for needy families, supplemental security income, any similar state benefits, and also institutionalization for long-term care at government expense. I do want to warn folks, they see these things and get worried about their own benefits. Really, this is a forward-looking thing. Most of the folks we're talking about wouldn't even be eligible for these benefits to begin with. But this is really looking forward to, do we think someone is going to become primarily dependent? Do we think someone's going to be relying on these benefits for their own subsistence? What we know is that the administration is trying to change public charge. They're trying to expand what kind of benefits would be included. So they're looking at things like SNAP, at housing. They are also talking about how they're talking about weighting factors, but the problem is they're not really talking about how they're going to weight them. So we know things such as if you're not of working age, that's going to count against you. If you have a chronic health condition, that's going to count against you. If you have limited English proficiency, that's going to count against you. But we have very little sense from what they proposed how they're going to weight these things. There's no kind of formula for us to look at. But what really has me most worried is that they're talking about increasing the minimum household income to 250% of the federal poverty level. Right now, it's at 125%. So they're talking about doubling household income in order for someone to be admitted to the United States. This is what really has me most concerned about this whole proposal. And what I always tell people is, so many folks are worried about being on benefits. I always tell them, look, it's not worth it getting off because you're probably on those benefits because you're below that 250% level. Just to give folks an idea of how this works, this is a regulatory change, so they have to go through a process that's mandated by law to do this. So it starts with they published the proposed rule in the Federal Register. That was done on October 10th of last year. That started a 60-day comment period that ended on December 10th. Right now, we're in that middle piece. So USCIS, U.S. Citizenship and Immigration Services, is basically going through these comments, and eventually they're going to publish a final rule where they actually have to respond to these comments. And according to the proposed rule that they had, this would include a grace period of 60 days. So anyone who's on public benefits would have 60 days to get off of them before they actually count against folks. That said, again, though, I'm worried about this 250% of the federal poverty level more than the public benefits. I anticipate that as soon as the final rule is published, that we're going to see a lot of lawsuits trying to block this. Folks are already gearing up around the country for these lawsuits, so we know they're coming. I can't give you any kind of guarantee about which way that'll go. So just keep your eyes open, keep an ear to the ground, because again, this goes very quickly. And we have no idea the timeline of when they will publish that final rule right now. There is the possibility of another rule coming out with public charge. And while what I was talking about deals with admissibility, getting the green card, this one could deal with deportability. That is, once you already have the green card. Now, this does exist in the law, and it's actually really difficult to deport folks under this. I have no figures, but I would say you could probably count the number of people who've been deported this way on one hand. And the way it works right now is that you have to receive benefits. Those benefits have to be received for a reason that existed prior to your admission. Basically what they're saying here is we should have found you a public charge because of this reason. We didn't. You got your green card and then you went on public benefits. You have to have received those benefits within 5 years of admission. They have to actually come after you. Under the law, they can come after sponsors to recoup any money that's spent on benefits for a sponsored immigrant. So basically, they have to come after someone. The government has to come after someone to get that money back. They have to have done that within that 5-year period. And finally, the sponsor has to fail to repay, and the government sues and wins that lawsuit. All of that has to happen for someone to be deportable under current policies. Now, we've been hearing forever that they're going to come out with a regulation to change this. There's little that they can change, particularly those first two pieces, that the benefit has to be received, or the reason for the benefit has to have existed prior to admission, and then it has to be within 5 years. That's actually in the statute. The administration cannot change that through regulation. We have very little idea of what they're going to do here, how they're going to make these changes. The suspicion is that this proposed rule will come out about the same time as the final rule for the admissions piece. And I do apologize, admissibility, deportability can be difficult concepts within immigration law to get, so I hope folks understood that. If not, feel free to send us questions. Right now, our messaging to the community is simply, look, nothing's changed yet. This has not taken place yet. We don't know when this change will happen. Again, there are probably going to be lawsuits. We believe, but again, I can't guarantee, but we believe that courts will probably block this, at least temporarily. We are strongly encouraging folks to, if they're on benefits now, to keep those benefits. If they're eligible for benefits, to go ahead and enroll for those benefits. And lastly, that this is not something we've given up on. This is a fight that's going to continue, and we'll see how this all plays out. DACA, I do want to go over DACA very quickly and just give folks updates on that. A quick overview of DACA for those who aren't familiar. It's been a while we've had it, you might have forgotten. So to be eligible for the Deferred Action for Childhood Arrivals, you have to have entered the country before June 15th of 2007. You had to enter before you turned 16. You had to be under the age of 31 on the date it was announced, which was June 15th of 2012. Means you had to be born after June 15th of 1981. You had to be undocumented on the date it was announced, so June 15th, 2012. Be in high school or graduated from high school and have no serious criminal issues. So where we're at now is that in September of 2017, the government announced they were ending DACA. There were a lot of lawsuits brought to keep it open. We saw cases in 4 district courts. 3 of them went in favor of protecting DACA. 1 actually denied the request for an injunction, but was later reversed by the circuit court. So right now, DACA is open for folks who have had it in the past. Anyone can renew their DACA, even if they've fallen off it. You can still renew your DACA. What you cannot do right now is do an initial application. So if you've never had DACA, you cannot get on it right now. And as Denzel mentioned, the Supreme Court will be hearing the case next term. The term starts first Monday in October. I do anticipate this to be one of the first cases we'll talk about, or that the court will talk about. So October, November, we'll probably see the oral arguments in the Supreme Court, and I would imagine a decision coming out in the spring. Temporary protected status, very quickly. So this is for folks who are from countries in crisis, but they're already in the U.S. So the way it works is that the administration designates a country for temporary protected status, and you have to be in the U.S. when that designation is made. And so the current list of countries with temporary protected status, you can see here. You can see some of these have been designated since 1999. We're talking about people who've been here at least 20 years. And the expiration dates on the right side, and those blue ones, again, this is the courts getting involved. So the administration said we're going to end temporary protected status for these countries. They got sued. Courts have basically said, no, you're keeping this open for now. So all those dates in blue there are ones that are being held open by court decisions. Complication with this is that folks who have temporary protected status, their evidence for their status is their work authorization documents. We call it an EAD, an employment authorization document. It's just the card that they get, the red card. Problem is the expiration dates on those do not match the expiration dates you see on here. Those cards are automatically extended, and employers or, when someone's going to renew their license or whatever, should be accepting the Federal Register publication saying that. But we've seen a lot of cases where that's not happening. We know that there are problems with the federal, what's called the SAVE system. At least in Massachusetts, that's what the RMV uses to check someone's status and make sure they're eligible for a driver's license. So we're seeing a lot of problems with that. We're working on it both locally and nationally. We hope to have a fix for that sometime soon, but who knows? And then the last thing I want to talk about is just the census. As folks know, the census is coming up. This has been in the news a lot lately. We did have a Supreme Court decision recently to keep the citizenship question off of the census, but it did leave a little path for them to put it back on, for the administration to put that citizenship question back on. So this is still kind of up in the air what's going on. There's still court cases going on in New York and in Maryland. We have no idea how this is going to shake out in the end. That said, we do really encourage everyone to fill out the census. There's a lot of educators on this webinar right now. Without accurate census counts, your school districts are going to lose federal funding. Your roads are going to lose federal funding. Healthcare is going to lose federal funding. All the money that our states get for almost everything we do from the feds is dependent on the census. So it's really, really vital that everyone fills out the census. There are laws that protect against the use of census information for law enforcement purposes. So there is a firewall there. Basically, that would prevent, just as an example, immigration and customs enforcement from accessing census data. And finally, we do just want to make sure people are aware that you can leave the census, if a citizenship question shows up on the census, you can leave that question blank. You do not have to answer every question on the census. Now, there are concerns that law enforcement could theoretically come after you for leaving a census question blank. Frankly, that's just not going to happen. They don't have the resources to do something like that. Also, for folks who aren't aware, the census this year is online. And there are some folks who are concerned that, well, if I leave questions blank, well, now I'm going to have an enumerator coming to my home. That's generally only going to happen if you leave a lot of questions blank. It's really doubtful that, again, it's a resource issue. It's really doubtful that they're going to come after someone to get more information just for missing one question. And so that's everything that I had. Please, we have the questions that you can send to here to the ILC, or if you want to just email me any questions, please feel free to do that. Thank you.
So your email address is there on the screen, sekhavat@miracoalition.org. Before you go, Sarang, I wanted to ask a couple questions. One is about enforcement.
Yes.
We are well aware that many people were deported under the previous administration. Has interior enforcement actually ramped up, and what are the differences you're seeing compared to, let's say, 4 years ago?
So interior enforcement has definitely ramped up. Although deportation numbers are down, we're seeing huge backlogs in the immigration courts. And in terms of the enforcement practices, under the old administration, they were much more targeted to folks who had a criminal conviction or who had a deportation order after January 1st of 2014. With this current administration, there's no priorities. They're just going after anyone and everyone. And that's really what's caused a lot of the fears. Before, under the Obama administration, there was a little more sense of security. That sense is really gone now. And there's a lot less that us as advocates are able to do working with ICE to try and help in individual cases.
And just to reiterate, for people who are currently on certain social safety programs, stay on them, correct?
Absolutely, absolutely. Our message to everyone is to please stay on those. People are on those benefit programs because they need them.